Hello everybody, today I'm going to represent the Federal Republic of Germany and their view on the interpretation of contracts. And I will take this opportunity to show you some of the most important cities, which you will find in the background of the slides. And moreover, I'm going to compare the system to the French and English legal system. Therefore, what I'm going to look at is the Declaration of Intent, good faith, the contra proferentum rule, and unfair contract terms, and last but not least, gap filling. We will start with the Declaration of Intent, which can be found in paragraph 133 of the German Civil Code, which primarily includes a subjective approach, namely the natürliche Auslegung, which entails that the aim of interpretation must be to ascertain the real intention of the parties, so their common intention. But if this is not present, then there will be an objective interpretation of the contract, so the normative Auslegung. So if we compare this to the French system now, we can see that France follows a subjective approach as well, since the common intention of the parties is relevant, which can be found in Article 1156 of the Code Civil. However, same as in Germany, Articles 1158 and 1160 lay down that unclear terms are interpreted according to the meaning of the contract in usage, which is a more objective approach. The UK used to have an extreme version of the objective approach. However, this changed in 1998 with the Investors' Compensation Scheme versus West Bromwich Building Society case, and it was ruled that interpretation is the ascertainment of the meaning which a document would convey to a reasonable person having all background knowledge which would reasonably have been available to the parties in a situation which they were at the time of the contract. So it is still an objective approach, and we can see that all countries adopt a compromise between attaching importance to intention and expression. So first of all, they look at the common intention, and if this is different, then they look at the reasonable meaning to the words in the circumstances of the case. And in the civil law countries, this reasonable meaning is, the starting point is to take the understanding of the contracting parties, and in the common law countries, they take the perspective of a reasonable person. Moving on to good faith, paragraph 157 of the Civil Code says that interpretation should take place in accordance with fairness and reasonableness, so Treue und Glauben, and furthermore, the general practice has to be taken into account, so this is called Verkehrssitte. Then Article 138 says that any legal act contrary to the accepted standards of good behavior are null and void. And a little extra provision is paragraph 242, which entails the obligation to execute contracts in good faith. In France, all legal agreements must be formed in good faith, which can be found in Article 1134 subsection 3 of the Code Civil. However, this provision is difficult to apply in practice since the scope of notion of good faith is not determined. UK law does not recognize a general principle of good faith. Therefore, it is no essential condition for the conclusion of a contract because it is seen to be contrary to the nature of contracting. And hence, in Wolford versus Miles, it was ruled that good faith is restricted to pre-contractual negotiations. And In another case, Chapman versus Honig, the judge ruled that a party must be able to exercise his right at all times, so here he meant the right to contract. And what the English system wants to tell us is that good faith restricts party autonomy and also the freedom of contract. However, the principle is recognized in some special contracts, such as insurance, partnerships, suretyship, and employment contracts, but also in consumer contracts due to the European directive. Next, I'm going to deal with the contra preferentum rule and unfair contract terms. And I want to start with saying that there has been a European directive on unfair terms in consumer contracts, which all member states have adopted, and therefore they all have this contra preferentum rule in their systems. And in Germany, this rule can be found in paragraph 305c subsection 2, which states that any ambiguities in a contract are interpreted against the one who drafted them. And paragraph 305 BGB entails this mandatory protection of the weaker party. Furthermore, Germany has an Act on General Conditions, the AGBG, which deals with any possible unfair terms in B2B and B2C contracts. Furthermore, there is Article 307, subsection 1, which grants a court the possibility to strike down an unfair term. And then in paragraph 308, we can find a gray list of unfair terms, which are not binding if they contain disproportionate elements. And in 309, we can find the so-called blacklist of unfair terms, which are terms considered not to be binding under any circumstances. As I said before, all of the three systems incorporated the contra preferentum rule, and in France, it can be found in Articles 1162 and 1602 of the Civil Code. So again, it says that unfair terms are to be interpreted against the drafter, and it also yields the mandatory protection of a weaker party. And also France has a specific control, which can be found in the Act on Protection and Information of Consumers of Products and Services. And the two lists I just mentioned for Germany, so the black and the gray lists, they have been taken over and incorporated in French law. In England, the rule can be found in the Unfair Terms in Consumer Contracts Regulations of 1999 in section 7.2, and in Davis, okay, I really don't know how to pronounce this, versus Williams, it was held that words are to be interpreted most strongly against him who uses them. And again, in the Unfair Contract Terms Act of 1977, the lists from Germany have been taken over. And by the way, they can also be found in the European directive, since it was kind of influenced by the German legal system. And next to that, the UK has a red hand rule, which means that the more unreasonable a clause is, the greater the notice which must be given of it. Let's move on to my last topic, which is gap filling. So ad hoc gap filling can be found in paragraph 157 of the BGB, and it basically entails the ergänzende Vertragsauslegung, so that in case parties have omitted to say something, the court must discover and take into account what they would have said, acting in accordance with good faith and sound business practice. So it's about the hypothetical will of the parties. And then, of course, there are also default routes, which may differ from subject to subject. and they're called zwingende Rechtsnormen or einschlägige dispositive Rechtsnormen. In France, ad hoc gap filling is called interprétation créatrice and can be found in Article 1135. And it states that agreements are binding not only as to what is therein expressed, but also as to all consequences which equity, usage, or statute give the obligation according to its nature. So basically, it obliges the parties to comply with all kinds of pre-contractual duties and advice, information, and warnings. And of course, France also has got default rules, which can be any kinds of rules for different topics. So England does not regard ad hoc gap filling as means of interpretation. It is called terms implied in fact. So the terms are not laid down, but it is assumed that the parties would have included them. And this includes the tests, so the officious bystander test and the business efficacy test. But I guess the English litigation will go more into depth about this. And what can be found as default rules in the civil law systems are terms implied in law in England, and the best example for this is the Liverpool City Council versus Irwin case, which was about common parts of a building which were vandalized, and the tenant said that there was a duty on the side of the landlord to keep those parts in a decent state. And then it was found that there was actually an obligation implied, which can be found in any relationship between landlord and tenant, and this obligation is to take reasonable care. So, well, that was my presentation. I hope I didn't forget anything and that you were still able to discern and detect my notes on the slides, even though I had quite colorful backgrounds. And of course, I hope you learned something, and I kindly request you never to wear socks and sandals. It's just a little tip. Tschüsschen!